Sexual harassment happens almost every day in our lives. We barely notice it because sometimes sexual jokes or sexual remarks have been common nowadays. However, only a few of us are aware about the danger that has been brought by sexual harassment in the workplace, educational institutions, and in public spaces. Our topic for today will be all about Philippine laws on sexual harassment. By the way, this is teacher Mike Arnel Granaderos from BSED2A. And before I will dig deeper to our discussion, let me define first what is sexual harassment. Sexual harassment is any form of unwanted verbal, non-verbal, or physical conduct of a sexual nature occurs with a purpose or effect of violating the dignity of a person, in particular when creating an intimidating, hostile, degrading, humiliating, or offensive environment. There are two laws that govern anti-sexual harassment in the Philippines. First, we have the Republic Act number 7877, or otherwise known as the Anti-Sexual Harassment Act of 1995, which prohibits sexual harassment in the employment, education, or training environment. We also have the Republic Act number 11313, or otherwise known as the Safe Spaces Act, which prohibits sexual harassment in streets, public spaces, online, workplaces, and educational or training institutions. What constitutes sexual harassment? Under Republic Act number 7877, sexual harassment can be happen at work, education, or training-related environment. Sexual harassment is committed by employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any person who having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted or not by the object of the said act. So take note here that sexual harassment in work, education, or training environment is committed by an employer, employee, manager, supervisor, teacher, instructor, professor who has the authority or influence or moral ascendancy. So, what is the gravamen of sexual harassment under Republic Act number 7877? Which means it is the abuse of authority, and by using that authority in order to demand, request, require any sexual favor from the other, even if that sexual demand or favor was not accepted by the victim. Under Civil Service Commission Resolution number 010940, the administrative offense of sexual harassment is an act or a series of acts involving any unwelcome sexual advance, request, or demand for a sexual favor, or other verbal or physical behavior of a sexual nature, committed by a government employee or official in work-related, training, or education-related environment of the person complained of. So take note here that the offender here must have also used his authority in order to perpetrate the crime sexual harassment. So what are the acts that constitute sexual harassment in a work-related or employment environment? Sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of a said individual. So, meaning to say, you will not hire a person if he or she will not accept the sexual demand or sexual favor, or in granting said individual favorable compensation, terms, conditions, promotions, or privileges. Means to say that you will promote the person if he or she will accept the sexual demand or sexual favor. or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee, which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. So, which means to say that you will dismiss or you will terminate the employment if he or she will not accept the sexual favor or sexual demand, or the bad acts would impair the employee's rights or privileges under existing labor laws. So, which means to say that the employee is intimidated, or the employee will not accept the sexual demand or sexual favor, it will affect his right under the labor code, such as, for example, his salary. So the employer may discriminate the employee by not giving him or his or her salary. Or the above acts would result in an intimidating, hostile, or offensive environment for the employee. So, which means to say that the employee is intimidated or she doesn't feel to be working at all in the workplace because of the sexual harassment acts. In an education or training environment, sexual harassment is committed against one who is under the care, custody, or supervision of the offender, or against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. Like, for example, the teacher and his or her student. When the sexual favor is made a condition to the giving of passing grade or granting of honors and scholarships, or the payment of a stipend, allowance, or other benefits, privileges, or considerations, uh, you will give a passing grade if the students will exact demand or sexual favor or sexual demand. When the sexual advances results in intimidating, hostile, or offensive environment for the student, trainee, or apprentice. So it doesn't confine itself to giving a passing grade. So if the sexual act or sexual advances will result into an intimidating, hostile, or offensive environment for the student, then that will already constitute sexual harassment committed in an education or training environment. If sexual harassment is limited to the person who actually committed the sexual harassment, the answer is no. Because under Section 3, any person who directs or induces another to commit any act of sexual harassment as herein defined, or who cooperates in the commission, therefore, thereof by another without which it would not have been committed, shall also be held liable under this act. So, meaning to say, if the person helps or cooperates with the commission of sexual harassment, even if that person did not commit sexual harassment, he or she also be held liable under Republic Act number 7877. Sexual harassment may take place in the premises of the workplace or office of the school or training institution, in any place where the parties were found as a result of work or education or training responsibilities or relations. So, for example, like if there is a JS prompt for the students and the JS prompt was held uh, at the hotel, since the JS prompt was conducted as education-related functions, any act of sexual harassment have been done or may have been taken place in hotel may constitute sexual harassment for the law, and therefore teacher trainer can still be liable for sexual harassment under Republic Act 7877. While on official business outside the office or school or training institutions or during work, school or training environment, or training related travel. Like for example, if the employee and his boss or supervisor has seminar that will take place outside their office, like they will go to Manila to attend a seminar and sexual harassment has taken place in the place where the seminar is conducted. So even if outside the office or employment institution, sexual harassment may still take place and the supervisor can be liable under the Republic Act number 7877 because they are in office business outside the office. At official conference, fora, symposia, or training sessions. Oh, so even if sexual harassment was merely committed via what? Via telephone, cellular phone, fax machine, or electronic mail. So even if sexual harassment was merely committed via cellular phone, your employer calling you, making sexual advances or sexual demand, sexual harassment may still take place. They can still be liable, provide, and of course, you must provide your record and support your record with evidence. So let's proceed to the illustrative forms of sexual harassment. We have the physical, the malicious touching, overt sexual advances, gestures with lewd insinuation. So as you can see in the pictures, the male person touches uh, the spot of the female. And the other pictures represents that the male was forcing or touching the female in an in a enforcing way. We have also the verbal or request or demands for sexual favors or lurid remarks, such as for example when the employer was said to his employee slut. So that is a sexual harassment. And another is use of objects, pictures or graphics, letters or writing notes with sexual underpinnings. So as you can see in the pictures, when the employee was reading a paper, then the employer was at beside the employer, then that would be called as sexual harassment. Now let's proceed to the section 4. The duty of the employer or head of office in a work-related education or training environment. So it shall be the duty of the employer or the head of the work-related educational or training environment or institution to prevent or deter the commission of acts or sexual harassment and to provide procedures for the resolution, settlement, or prosecution of acts of sexual harassment. So the main duty of the employer here is to settle this sexual harassment. He or she was liable if he did not do his part or duty, which is to make settlement and to prevent sexual harassment uh, will happen. Now let's proceed to the section 4, which promulgate appropriate rules and regulations and consultation with a jointly approved by the employees or students or trainees through their duly designated representatives prescribing the procedure for the investigation of sexual harassment cases and the administrative sanctions therefore. Administrative sanctions shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. The said rules and regulations issued pursuant to the subsection shall include, among others, guidelines on the proper decorum in the workplace and educational or training institutions. So the employer and the employee must be all together to establish the rules and regulations for them to be aware and for them to be guided. What would be the rules or the law that they are going to follow? Now let's proceed to section 4 again. Create a committee on decorum and investigation of cases on sexual harassment The committee shall conduct meetings as the case may be with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of alleged cases constituting sexual harassment. So, the teachers or the employers and all of the member of the company or in the education institutions must be educated with regards to the sexual harassment for them to be aware how they are going to prevent these sexual harassment issues. Aside from that, in the case of a work-related environment, the committee shall be composed of at least one representative each from the management, the unison, if any, the employees from the supervisory rank and from the rank and file employees. In the case of the educational or training institution, the committee shall be composed of at least one representative from the administration, the trainers, instructors, professors, or coaches, and students or trainees as the case may be. The employer or head of office or educational or training institution shall disseminate or post a copy of this act for the information of all concerned. Now let's proceed to the section 5, which is the liability of the employer, head of office, educational or training institution. The employer or head of office, educational or training institution shall be solidarily liable for damages arising from the acts of sexual harassment committed in the employment, education, or training environment if the employer or head of office or educational or training institution is informed of such acts by the offended party and no immediate action is taken. So for in this part, if the employer or the head are he or she is fully aware but he did not do some actions just to resolve these issues, he or she is liable for the law. Now let's proceed to the section 6 independent action for damages. Nothing in this act shall preclude the victim of work, education, or training related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. So what are the penalties for offenders? Any person who violates the provisions of the law shall be penalized by imprisonment of not less than 1 month nor more than 6 months, or a fine of not less than 10,000 pesos nor more than 20,000 pesos, or both such fine and imprisonment at discretion of the court. Any act on arising from the violation of the provisions of this act shall prescribe in 3 years. So, if you commit sexual harassment act during this time, so that act would constitute to 3 years imprisonment because of doing the act of sexual harassment. So I guess that would be all. And in my conclusion, sexual harassment should be prohibited and should be the people should be aware about this issue because sexual harassment has been common nowadays, and we as a youth should encourage others to be fully aware and be fully educated when it comes to sexual harassment. Okay, everyone, thank you for listening, and once again, good morning, and I hope that you've learned something in my discussion. That would be all, and thank you.